And I know Chairman Leach is not in the room, but we thank him for allowing us to visit with him about our concerns, and as well as inviting us to meet with the stakeholders, namely Uber, to visit about our concerns on this bill. So these California tech companies have come into Texas, and it's a high-risk business, and that's why they have to carry the policy that they do. But Uber and Lyft and the others are entrusting drivers who are minimally qualified with our Texas families, and our most precious treasures, our daughters and our sons. And therefore, there are exceptions within Texas statutes, although they are afforded protections, unlike other industries. For example, trucking companies, highly regulated, can be sued for vicarious liability, can be sued for gross negligence. So they are afforded protection regarding independent contractor, but there are exceptions. And those exceptions include if there is control of the driver, actual control, if they enable the driver to be distracted, which the app very well can distract while I am in an Uber or a Lyft and I am a passenger. Sometimes those drivers can accept new rides, which requires them to look at the app and be distracted. And of course, in the event of sexual assault cases where the rideshare companies are required to do the background check, and if they don't, there is an event. But the only way to get to the truth, the only way to get that evidence is discovery. And that brings it, so Section 005 of the bill is problematic because these rideshare companies would be held to the lowest standard of care, where they would only have to show that they didn't commit a crime under the penal code, state or federal, which is unlike, again, any other industry in Texas to be afforded such protection. The Section 003 does create the legal impossibility where the lawyer would have to swear under oath that is more than sanctions. That could subject the lawyer to perjury. If the facts don't turn out, it essentially makes the lawyer a fact witness in the case, creating a conflict because that attorney may only have a police report and was not in the vehicle as a fact witness. So that is part of the issue, because at the end of the day, a sexual assault victim would not be able to find an attorney if attorneys were not willing to risk their license and risk perjury. So that is Section the other issue with Section 003 is the other legal impossibility of having to find an expert witness who could testify that all damages, including non-economic damages, would total over $1 million in advance of any discovery. The Supreme Court has been instructive that we cannot hire experts on hedonic damages to go in and testify about mental anguish, physical impairment. There may only be very little in medical bills with a sexual assault victim, but great damages with mental anguish, pain and suffering, and other trauma. And those damages are within the province of the jury once and if the case is tried. So the other issue I wanted to address is that we want for the committee to have all of the information. And once we met with Uber and their counsel, we did ask if they would waive the confidentiality and non-disparagement agreements for those victims, just to tell their experience with provisions without disclosing anything other than the facts that are public. And we were told no. So the other issue is just suing the driver from the outset. That driver may not have access to the platform data or to the communications between the rideshare and the driver, or the complaints that have been made about the driver, or reviews. If the driver is involved in a crash and there are reviews within their system, which they have to, under Texas law, keep for 2 years, that information of the rides, then there have been cases with obstructed discovery, pretty heavy-duty protective orders. They're, not engaging in sharing provisions. So it's very difficult to just sue the driver and then believe that you can access information from a California company that would require discovery potentially from a third party if they're not essentially a party. Therefore, to gain discovery, to find the evidence and the truth, Uber is sued. That way we would be able to learn if they violated any of the statutes in Texas and learn if they had controlled actually the conduct of the driver or knew from complaints that submitting them to vicarious liability. So I don't know where my time is because I no longer see the clock, but I am happy to answer any questions. Oh, well then.
Laura, I think you've got some questions. Chairman
Technical.
Chairman Moody. Actually, members, after this witness, we're going to leave this bill pending temporarily, and we're going to take up some pending business and come back to it. So, Chairman Moody.
Thank you, sir. And you mentioned it at the top of your testimony. I want to circle back to it. Opportunity to have stakeholder meetings. Chairman Leach is always very good about making sure that those get set up. We deal with, obviously, as this data has shown, we deal with a lot of issues that people come from far apart on, and I have seen a lot of those meetings go very well to where everybody can walk away, and that's always my preference. If we're able to find that ground, let's find it. If we can't, I mean, that happens too. It's a rarity. What can you, if you're able to, let us peek behind the curtain and how that's gone? Where do you feel there's space when you have those stakeholder meetings to do some work on this? Because it seems like this is one that people are a little bit far apart on.
Right. So in this instance, in meeting with Uber and their counsel, the question was, what is the impetus for the bill? And the answer was, we're getting sued in every case, even when there isn't vicarious liability. And, you know, part of us being a comparative fault state is, you know, you sue the parties based on maybe a police report or based on information, and then you're allowed to discover. Because there are exceptions to a ride share being liable for vicarious liability, that has to be discovered. If there is no instance where there is vicarious liability, they have the affirmative defense, and actually, you know, quite a few defenses within the occupations code that you don't see for a general contractor, that you don't see for trucking companies or other industries that are sued for vicarious liability. The question of direct negligence and that they can still be sued for that is another conversation that we had. And the issue is when there's not an employer, employee, principal, agent, direct negligence actions of supervision, hiring are difficult when there's not that relationship. So there's a question there. And those were the conversations that we had, but more importantly about, are there any other states that have the affidavit requirement? And we were provided with the Florida statute. They don't have the affidavit requirement. I think there's pending legislation in Missouri, doesn't have the affidavit requirements, the 2 affidavit requirements. So I'm sorry.
I'm so sorry. It's been a long day. You said that Florida does or does not have?
Does not. So
to me, it seems like we're trying to do things like Florida nowadays. And that seems to be the flavor of the day. So that's an interesting point.
So really, that started the discussion, and we were trying to find out, tell us about the cases where you shouldn't belong. How many are there? Is it a ton? Is it a flood of this frivolous litigation? And that is still information that we're waiting on.
Okay. Can you, I mean, I guess how those conversations go in advance is important, particularly with our timelines and how things work here. So I'm sure you're informing the chair of those things. If you could also keep us up to date on how those are going.
I am happy to,
Mr.
Chairman.
Members, other questions? Vice Chair Johnson.
Let's talk about affidavits. Are you aware of any circumstances where the lawyers have to provide a personal affidavit of sworn testimony verifying the facts of the case?
No, Madam Chair, I don't.
And then not only that, but then they want to add an affidavit that plaintiffs have to hire by a third-party expert to testify on damages too, correct?
That is correct.
That is also nowhere. when you have to provide a damages expert?
They're right. To find an expert qualified in non-economic damages is something that we don't do because, again, that goes back to the province of the jury.
One of the only spaces I'm aware of where at the inception of a case, plaintiffs have to hire under Chapter 74 medical malpractice cases, but it's on liability facts, it's on negligence. And, but this is a whole different scope of what that is.
That is correct.
Yeah. Thank you.
Thank you.
Members, any other questions for this witness? Okay, thank you. Right now, the chair is going.